Hello. In conclusion, my team will be discussing the closing argument case for Able and the Imaginary Apartments. My name is Jessica Jenkins, and I'll be discussing the issue and the facts about this case.
Hi, my name is Jordan Ludlam. I am a part of Group 6, and I will be discussing the facts against Abel Joseph as well as why these facts aren't relevant to our case. I hope you enjoy.
Hello, everyone. My name is Krista Vladiou Cavacles, and I will be presenting slides 6 and 7. 6 will be rationale, and 7 is how could this all be avoided. Thank you, and I hope you enjoy.
My name is Taylor Lucido. I'm the team captain, and I'll be doing the ending statement and also the teamwork slides. So I hope you enjoy. Thanks.
Our issue for this scenario pertains to the Americans Disability Act. We are here today to discuss a very special circumstance that requires adherence to ADA law. Was Mr. Joseph wrongfully terminated due to not putting his disability on his job application? That's what we're here to find out. Mr. Joseph suffers from non-epileptic seizures. He was hired by Imaginary Apartments 9 months prior from the occurred incident. He brought his service dog to work with him after finding that he was beginning to get signs that he was going to have an episode. He was terminated after bringing his service dog to work, which immediately tells me that he was terminated for his disability. No warning was given before termination. Mr. Joseph feels that his disability would have had him immediately discriminated against if he had put it on his application, which seems to be what is happening here. He did not need any accommodation for 9 months, which tells us that his disability is irrelevant to his job performance.
Facts against Abel Joseph. The only fact against Joseph is the incorrect information on his job application. According to Imaginary Apartments and Sherry, his actions were dishonest and fraudulent in nature when he didn't put that he was disabled onto his job application. There is a law called the After Acquired Evidence Law, which is used to protect employers from these types of situations. It has to do with facts discovered about the hired employee and the employee's fraudulent claims. When an employee lies to get a job and is then fired, despite your rights, they are unable to sue. So in this situation of him not putting that he was disabled onto his application, then trying to sue the company, I foresee this law being brought up. This law could put a wedge in Joseph's lawsuit. Why these facts against Abel Joseph aren't relevant. The After Acquired Evidence Law, while important, may not hold up for the employer. It doesn't fully protect an employer. It can, but not always. It may simply just lower the suit against them. Joseph's application could have been considered dishonest and fraudulent, but it is not illegal to disclose his disability. ADA law protects him from having to disclose his disability to an employer. His disability can be kept unknown, and especially since it wasn't a threat to his job performance. He did not withhold anything that is required to work for their company: degree, criminal record, drug abuse, work history, and so forth. Had the company required a master's degree and he disclosed that he had one but ended up not having one, then he wouldn't have grounds to sue. So, while this could be considered lying by definition, it is not punishable. ADA law trumps everything else regarding this situation because he doesn't have to disclose his disability even on job applications. His disability had no relevancy to him being hired over someone else, and that's what ADA law protects against. Another point to make: most applications have a yes/no column for disabilities. He didn't have to put that he was disabled, so how would he have not disclosed that information if there is only the answer yes or no? Which then makes the application completely irrelevant when it comes to his special circumstances with disability in ADA law. This then shows that Imaginary Apartments has no grounds to terminate Joseph.
Let's review the case and laws attached before we can conclude. We have the plaintiff Abel Joseph, who worked for Imaginary Apartments for 9 months. Joseph suffers from non-epileptic seizures, but this does not affect his work performance. Imaginary Apartments was unaware of this due to Joseph not disclosing this information on his application until Joseph brought in his service dog. After finding out Joseph's disability, they proceed to fire him because he lied on his application. Then we have where the employer questioned the dog's presence. This was lawful because it was light questioning about the dog. No laws were broken yet. Joseph then continues to describe his disability. While nothing was done illegally, Joseph was not required to disclose this information in accordance with ADA law. Joseph is then given the day off and then the following days off after to recover. Then is fired out of nowhere because he didn't disclose he was disabled on his application. While on the surface there seems to be no illegal action, though through research into his disability law and regulations, we find there are violations made by imaginary apartments. Joseph should not have been held responsible for not disclosing on his application because it was in terms of his disability, which was covered under the American Disability Act. It is clear Joseph was fired due to his disability. Yes, it was stated that Joseph was fired for lying on his application, but it is coincidence that he was fired right after finding out about his disability. Joseph could work for his company with no issues and no accommodations for extended amount of time. The company should have abided by the ADA and accommodated Joseph's service dog whenever he felt he needed to bring his dog into work. This company is not willing to make any minor accommodations for Joseph's disabilities, and this is a clear violation of ADA. He was discriminated against the minute the workplace found out about his disability. The court should rule in Joseph's favor, and he should be compensated for the emotional turmoil as well as the time lost by being terminated by imaginary apartments. They are in violation of federal law and should be fined. No one should lose their job or fear about losing their job because of disabilities. These laws were established to help protect anyone with a disability, and every company should be held accountable for not abiding by the ADA. Joseph should have known his legal rights regarding his disability when it comes to his employment. He would have then considered calling in sick instead of bringing his dog to work if he felt that discrimination could have been a possibility. Secondly, imaginary apartments should have trained their management team to know these types of situations, such as ethics and employment law training. If they opt to not train them, they should have had a specialty department in HR to accommodate sensitive circumstances such as disability disputes. A manager's job is not only to supervise their employees, but also they are representative of their organization. I do not agree with the decision of the manager to fire Joseph due to his health issues. Rather, I would evaluate his work ethic the last 9 months to determine if he was a good fit for the company. Her actions have put the company at risk for a lawsuit.
Now our ending statement. I implore you to consider the main points of why Joseph should not be held responsible for incorrect information on his application. Americans with Disability Act. It states that he is not required to disclose his disability information on any application, nor to any employer in his career. He should not have been fired by imaginary apartments. They had no grounds to do so. He did not lie about his abilities to perform the job required of him, which is the main reason why he was hired in the first place. He upheld what he said he could do, and has been doing so for 9 months before this incident. It is clear that Joseph was fired due to his disability. Imaginary Apartments has no regard for anyone with a disability. They should have known this was a sensitive topic, a sensitive situation, but they did nothing. This company is not willing to make any minor accommodations for Joseph's disability, and this is a clear violation of his ADA rights. I believe that given all the information that we have acquired, that Imaginary Apartments is in violation of ADA law, and Abel was discriminated against. He should be fully compensated for the time lost and the emotional turmoil he has suffered. We completed this assignment with the best of our ability as an online team. It was a hard assignment because we had 4 individuals with time constraints, work schedules, and we all found it hard to find time to talk together. The only thing that seemed to be effective was constant communication via text. It didn't always get the point across, though. Information had a hard time traveling back and forth, and we feel that if this hadn't been an online class and we all could have been in a classroom together for at least an hour every week, we could have done a better job. We felt that there was a lot of confusion and could have all been reduced if we were able to have visual aids and worked each part out together instead of separately. We were unable to come together with all four of us at the same time via anything but text messaging, and I, as a team captain, felt that it hindered us as a group. On the bright side, though, besides a lot of confusion, we did not have to resolve any issues regarding participation, effort, timely turn-ins. We all had the project ready to go every week and kept up with it, even with all of our different schedules. I feel that this project opened all of our eyes to the things that we should know as business majors. It's so important to be well informed, and this could have been any of us as we grow our careers. In our future endeavors, I feel that we will be more conscious of our work environment policies, might even take it upon ourselves to become informed when we don't know the direct answer for cases such as this one. Knowing the policy, going above and beyond to research law and ethics, might save our future workplaces a headache with lawsuits that could have been avoided with information that is just a click away via the internet. We have learned that not everything is a surface problem, and in the end, can be a lot deeper than we first thought. The Americans with Disabilities law had a huge impact for this scenario. It turned our whole view around just by becoming informed with what is out there. At the surface, it looked like a clean cut. He lied on his application. But in the end, after diving more into it, the ADA law turned that first thought into a clear 180. This scenario has allowed me to realize that being ignorant to business law is no excuse. Anyone can know law just by taking the time to look it up. It's that simple, and yet so important.